Colleagues, we're going to now move on to the next item of business, which is a debate on motion 23218 in the name of Murdo Fraser on Scottish Government handling of harassment complaints. I would urge all members who wish to contribute in this debate to press their request to speak buttons, and I call on Murdo Fraser to speak to and to move the motion in his name.
Thank you, Presiding Officer. This afternoon, the Scottish Conservatives are dividing our debating time into two parts. Shortly, my colleague Donald Cameron will be leading a debate looking at the crucial issue of the impact of the COVID-19 pandemic on our care homes. In advance of that, I am leading this short debate calling on the Scottish Government to publish the legal advice it obtained in relation to the judicial review taken against it by Alex Salmon in connection with its complaints procedure. And I should say at the outset that I regret we're having to spend debating time in this Parliament on such an issue. It has only been made necessary because of the failure of the Scottish Government to respond to consistent calls from members of the committee, speaking unanimously and on a cross-party basis, for publication of vital information that the committee believes is essential to allow us to do our work. This led to the committee convener, Linda Fabiani, stating on the 29th of September that the committee had been completely frustrated by the lack of evidence being provided from the Scottish Government, amongst others. A vital component in this missing information is the legal advice that informed the Scottish Government's decision-making, and specifically its decision to defend the judicial review pursued by Mr Salmon. We know that Mr Salmon had Council's opinion, which said that his prospects of success in that case were substantial. And we know that the Scottish Government conceded the judicial review, admitting that Mr Salmon was correct. And we know that the award of expenses paid to Mr Salmon, over £500,000 of taxpayers' money, was at the highest level available in these circumstances. A level of award only made where the defence has been conducted, in the words of Lord Hodge, either unreasonably or incompetently. So we know that something went very far wrong with the Scottish Government's legal case, and we need to understand why this happened and what led to this loss of public funds. It is surely a matter of legitimate public interest to understand this catastrophic failure within the Scottish Government, and one which cost the taxpayer so dearly. Presiding Officer, there is a long-standing convention that legal advice given to ministers is confidential, and that convention exists for good reasons. But that convention can be overridden where there is an overwhelming public interest, and I believe that that applies in this particular case. The Scottish Government have themselves published their own legal advice on a number of occasions, in the contaminated blood scandal case, on the Scottish Child Abuse Inquiry, and in relation to the Edinburgh Trams Inquiry. So they have in the past chosen to publish legal advice, and there is no restriction on them doing so. We have had repeated promises from the First Minister and from the Deputy First Minister that the Scottish Government will cooperate with the inquiry. On the 17th of January 2019, Nicola Sturgeon told this Parliament, "The inquiries will be able to request whatever material they want, and I undertake today that we will provide whatever material they request." She went on to say, "My commitment is that the Government and I will cooperate fully with it." If those words mean anything, Presiding Officer, then the Scottish Government should publish the legal advice the committee is seeking. On the 1st of October this year, the First Minister told the Chamber that all the information the committee had asked for was being provided, except where there was a legal reason why it could not be. That statement is, I'm afraid to say, simply untrue. There is no legal reason why the legal advice we are seeking cannot be published. It is simply a matter of political choice by the First Minister and the Scottish Government. There is nothing in law preventing it from doing so. So why does this matter, Presiding Officer? Well, we know that the legal stance taken by the Scottish Government led to the loss of the judicial review case, and with it, over £500,000 of taxpayers' money paid to Mr Salmon for his legal costs. If it is the case that the legal advice obtained by the Scottish Government, either in-house or externally from Council, said they had a good case to defend, then lessons need to be learned as to why such poor advice was offered, to ensure no repetition in the future. The alternative explanation is much more sinister and concerning, because Mr Salmon's allies believe that the legal advice obtained by the Scottish Government told them that the judicial review case should not be defended, as there was very little chance of success. And if that is indeed what the legal advice said, then it means that a decision was taken at the top of the Scottish Government to go and defend the case regardless, a decision which, in the light of what we now know, was both irresponsible and reckless. More worrying still is the accusation that that decision was made on political grounds, and in effect the Scottish Government were pursuing a vendetta against the former First Minister and using public funds to do so. Now, Presiding Officer, that claim may well be nonsense, but it is impossible for members of the committee, or indeed the public as a whole, to reach a view on which of these explanations is the correct one in the absence of the legal advice. And that is why its publication is so vital to the inquiry. And it explains why all members of the committee, across all 5 political parties represented in this Parliament, have joined together in making the calls for the legal advice to be published. As matters stand, it is hard to avoid the conclusion that to date, the Scottish Government have treated this inquiry with something close to contempt. In addition to the refusal to release vital information, we have now had an astonishing 4 occasions on which senior civil servants have come to the committee and given oral evidence, and then have had to write to the committee subsequently to correct misleading statements which have been given in a public session. That is simply not good enough. Presiding Officer, it is essential to the work of the committee that the legal advice is made available to us. I hope that the Scottish Parliament will agree today to support my call for its publication, and if we are successful in winning the vote later this afternoon, I would expect the Scottish Government to respect the parliamentary vote and produce the missing documentation as a matter of urgency, and in so doing, fulfil all the promises that have been made by the First Minister and the Deputy First Minister to be open and cooperative with this inquiry. To do otherwise, Presiding Officer, would be unforgivable. I move the motion in my name.
Thank you. And I call on the Cabinet Secretary, John Swinney, to speak to and move Amendment 23218.2. Mr Swinney.
President Officer, I rise to move the amendment that stands in my name. Scots law provides that any person who seeks legal advice has the benefit of confidential communications with their lawyer. This is an important and well-established legal principle. In the same way, legal professional privilege is part of the normal operation of the Scottish Government. It supports good government by allowing ministers and officials to be informed by appropriate and full legal input when making decisions. Legal privilege is inherent to the functioning of good government and the rule of law. It is important that the legal advice which ministers and their officials receive is full and frank and not affected by concerns about it subsequently becoming public. The principle of legal privilege has been upheld and respected by successive Scottish and United Kingdom governments of different political colours on a range of topics and including on very high-profile issues. This includes recently the Conservative-led United Kingdom government in relation to issues in connection with Brexit. Governments operate on the principle that legal privilege applies, and this allows for open and candid legal advice to be taken to inform the process of decision-making. Legal advice does not constitute a democratically taken decision. If Mr Johnson would forgive me, I need to make a bit of progress. I've got a lot of ground to cover. It is advice that informs that decision. It is the decision itself that the government is accountable for. And in the case at the centre of this debate today, the handling of the judicial review, the Scottish Government's decision-making, essentially its legal position in the case, is set out in the pleadings in the case, informed by the legal advice that we have taken. These pleadings have already been shared with the committee, including various changes and developments that took place during the handling of the case, as set out in a detailed timeline document, again, which has been made available to the committee. This is one aspect of the information that the Scottish Government has provided to the committee in making available the documentation that the committee has requested. Maintaining legal professional privilege has not prevented the government from providing the committee with over 1,000 pages of relevant material. Scottish Government witnesses have provided over 14 hours of oral evidence to date. We are working to provide more material to the committee and have set out our intention to initiate legal proceedings seeking to allow the release of further documents that we believe the committee should receive. The First Minister and myself have both personally provided written evidence, and the First Minister has made clear her willingness to attend the committee in person when asked. Our cooperation has also included the Lord Advocate, making himself available to provide oral evidence to the committee on relevant matters. He has already attended committee on the 8th of September and will be attending again next week. The Lord Advocate gave detailed answers on the issues at the heart of this debate at committee. He explained, and I quote, "It is really important to say that the assertion of legal professional privilege is routine. Its waiver is exceptionally rare, and it happens against the background of very strong reasons of public policy for..." If Mr Mundell would allow me to finish the quote, and then I will give way to him. "Its waiver is exceptionally rare, and it happens against the background of very strong reasons of public policy for maintaining that confidentiality, which facilitates and encourages the seeking and receipt of legal advice by policymakers and ministers on a basis of absolute candour. In the context of a litigation where inevitably the government's previous legal position may come under scrutiny and test, it is particularly important that the government is not disincentivised from seeking and obtaining legal advice on the basis of absolute candour. It is also fair to say that the more an issue is a matter of live political debate, the greater is the risk that a waiver of privilege would undermine that." That's the end of the Lord Advocate's quote, and I'll give way to Mr Mundell.
Oliver Mundell.
I thank the Deputy First Minister for taking an intervention. Does he honestly think that in this case the circumstances are routine? Does he not think this is exactly the sort of exception where the public interest test kicks in?
Cabinet Secretary.
I think this is, if Mr Mundell looks at the examples where the government has waived legal professional privilege, they have been on major issues of public policy in relation to historic child abuse or contaminated blood or other issues of that nature. This is an issue of litigation, and the point the Lord Advocate made, no, I'm answering the intervention, and the point the Lord Advocate made in the quote that I've read out is that this is particularly relevant in a situation where matters are the subject of litigation for the principle of legal professional privilege to be applied. The government, I'm afraid I'll have to make some further progress. The government is frequently involved in litigation and decision-making as part of normal good government. As the Lord Advocate noted in his evidence, it is crucial that decisions can be taken with the benefit of full and frank legal advice. If the government were to waive its privilege in this case, I would be concerned that in any future high-profile litigation involving the government, ministers might not be able to benefit from advice given on a full and frank basis, should there be a fear that advice might be published. All of us surely must recognise the benefits for public policy and decision-making for the government to be able to benefit from being able to take legal advice which is robust, which considers all possibilities and weighs up all considerations. None of us surely want public policy and decision-making to fall victim to legal advice that errs on the side of caution for the fear of its publication. The strength of legal privilege stems from a consistent application by a client, in this case the government, across its legal communications. Picking and choosing what to make public does not assist decision-makers make sound, reasonable decisions or assist Parliament and the public to hold a government to account. I have carefully considered the request from the committee that the Scottish Government waive legal privilege in this instance. I have concluded that the public interest in maintaining the privilege, including the negative impacts of waiving privilege for all areas of government operation, outweighs any perceived public interest in disclosing legally privileged material. The Scottish Government continues to assert legal professional privilege in relation to the work of the committee. This will not prevent us from continuing to cooperate with the committee's work in the supply of documentation and the provision of witnesses. That has been the commitment of the Government throughout this process, and it will remain so for the remainder of this inquiry.
Thank you very much, Cabinet Secretary. Can I call Jackie Bailey?
Thank you very much, Presiding Officer, and let me start with the words of the First Minister to the Chamber on the 17th of January 2019, because I think it is worth reminding us what she said. The inquiries will be able to ask for whatever material they want, and I undertake today that we will provide whatever material they request. My commitment is that the Government and I will cooperate fully with it. Let's be clear, Nicola Sturgeon was speaking as the First Minister of the Scottish Government. She wasn't speaking in a personal capacity. There were no caveats to what she said. That means the Government should be committed to openness and transparency. They should be providing the committee with whatever material they request. The Deputy First Minister is, however, reinterpreting what the First Minister said to mean something completely different. Contrary to what the Scottish Government say, the committee has had partial information, pages of white paper with no information on it at all, because it's all been redacted, delayed information, and in some cases no information at all. Information on complaints handling was supposed to be provided to the committee by the end of August. We are now in November, and we're no clearer about when it will be received. Now, I wouldn't object so much if the establishment of the committee had been yesterday or even last week. But it was more than 18 months ago. So it should be no surprise to the Scottish Government that the committee would want this information. The question of the judicial review is central to the committee's remit. It's the remit that the SNP also agreed with. Understanding the legal advice given to the Scottish Government is therefore key to determining whether they pursued the judicial review appropriately or whether they actually wasted public money. Let's remember it was £500,000 given to Mr Salmond and his lawyers. And that's on top of the cost of external counsel for the Scottish Government at £118,000. Never mind the cost that we've discovered of a whole array of officials meeting, in some cases daily, at least 10 to 12 of them lawyers, another group meeting 3 times a week, involving comms people, policy officials and special advisors, and then, of course, the 17 meetings with council. A huge investment of public money just on this one case. There is, of course, precedent for providing the committee with the legal advice taken. Government legal advice was provided to the UK Blood Inquiry, the Sexual Abuse Inquiry and the Trams Inquiry. Why is a parliamentary inquiry of less importance and status to the Scottish Government than a public inquiry or indeed a government inquiry into trams? What we need to remember is this is about the women who complained about experiencing harassment in the Scottish civil service. And with all due respect, they are much more important than trams. They deserve the committee to do its job, to understand what went wrong and why they were failed. And for those who come forward in the future, there needs to be trust in a process that is not subject to challenge. So for the Scottish Government to withhold that important information from the committee actually lets these women and other women in the future down. Despite repeated letters and requests, despite the convener having to put her foot down very publicly, and I pay tribute to her for doing so, the Scottish Government continues to stick its fingers in its ears and refuses to provide the information. Presiding Officer, this is simply not good enough. And this evening, I hope the Parliament votes for the release of the legal advice provided to the Scottish Government. And if the Scottish Government ignore the will of this Parliament, then we can only assume that they really do have something to hide.
Thank you. And I call on Andy Whiteman.
Thanks very much, Presiding Officer. On the 6th of February 2019, Parliament voted to establish a committee to inquire into the Scottish Government's handling of harassment complaints in light of allegations made against former First Minister Alex Salmond, which led to the judicial review which was conceded by Scottish ministers at a cost of over £500,000. And the point of such an inquiry is to establish what exactly happened and, as a result, to help make sure that such procedures are fit for the future. The committee, as we've heard, has asked on a number of occasions for the legal advice referred to in the motion, but the government's refused to hand it over. Now, I acknowledge the Deputy First Minister's point that ministers do not, as a rule, publish legal advice. To do so, is argued, would compromise the requirement for frank and independent advice. If the providers of such advice knew that it could be released later at a later date, such frankness could be compromised to the detriment of good government. And yet, as we've heard, in recent years, the government has refused to publish legal advice over the legality of a second independence referendum without a Section 30 order, has refused in response to requests from the Law Society of Scotland to publish its legal advice in relation to the Continuity Bill. But, Presiding Officer, legal advice can be published if the public interest requires it, as Murdo Fraser mentioned. Section 21 and 28 of the Inquiries Act 2005 gives powers to the chair of any public inquiry to require evidence and documents to be produced, including legal advice. Under the Freedom of Information regime, legally privileged information is a statutory exemption, but again the Freedom of Information Commissioner can order disclosure where there is a compelling public interest to do so, and given that there has been a Freedom of Information request for this information, may well yet do so. As set out in the letter of 7th of September to the committee by Mr Swinney, the Scottish Ministerial Code, para 240, makes clear that disclosure can be made if, in exceptional circumstances, ministers feel that the balance of public interest lies in disclosing the source or the contents of legal advice on a particular matter. Now, the committee, of course, Presiding Officer, is not a public inquiry, but it is a special committee of Parliament. It's been established by a resolution of Parliament to inquire into specific matters of public interest in relation to an apparent serious failing of government. So the idea that legal privilege, professional privilege, always applies is wrong. It can be overruled by a public inquiry, it can be waived under FOI, and where considered appropriate by ministers, they can waive it under the Code. And indeed, in John Swinney's letter to the committee of 30 September 2020, he states, the committee notes that the Scottish ministers have on previous occasions chosen to waive legal privilege, did not impose a restriction notice on the disclosure of legal advice to the Scottish Child Abuse Inquiry or the UK Infected Blood Inquiry, as well as limited disclosure in the Trams Inquiry. And so to repeat, legal professional privilege is capable of being waived where the public interest demands it. And so, Presiding Officer, the only real question facing the Scottish Government and Parliament is whether it is in the public interest to disclose the legal advice. Government has claimed that in its view it is not. But this Parliament is being invited today to, in effect, decide that question, whether it is in the public interest or not for this advice to be released. And I submit that this democratically elected Parliament is a better barometer of the public interest than the government, who are an interested party in this inquiry. Scottish Greens believe that it's in the public interest, since the whole point of the committee's work is to consider the government's handling of complaints under the complaints procedure, the very substance of the judicial review, and thus why the legal advice plays a central role. The Deputy First Minister said that ministers make decisions, but assessment of that decision-making, critical scrutiny of that decision-making, cannot be done in the absence of the information that informs it. And so, Presiding Officer, the committee has by unanimity asked the government for this advice. MSPs from every party in this Parliament have agreed that the committee needs to see this advice. This committee serves the Parliament, and so this evening I'll be particularly interested in how SNP backbenchers vote. Do they stand up for their parliamentary colleagues on the committee and join with all other parties to support the committee in its endeavours? Or do they defy their parliamentary colleagues and side with the government, who are refusing to release this advice and who are, as I say, an interested party? Thank you, Presiding Officer.
Thank you very much. And I call Alex Cole-Hamilton.
Thank you very much, Presiding Officer. I'm grateful for the opportunity to rise in support of the Conservative motion tonight. I will come on to the substance of the legal advice in a moment. But before I do, this is not the speech that I had originally intended to give. Had my amendment been selected last night, I would have set out why this Parliament should direct the Scottish Government to urgently expand the remit of the Ministerial Code investigation into the actions of the First Minister. At this time, James Hamilton QC is only charged with investigating the meetings held between the First Minister and Mr Salmond connected to the complaints against him and the government investigation of the same. But our inquiry has been past significant and detailed evidence that now casts doubt over the First Minister's version of events. And for legal reasons, this cannot yet be published, but I know I speak for colleagues when I say that when we saw it, we recognised the immediate need for the ministerial code referral to be expanded to examine whether Nicola Sturgeon knowingly misled Parliament under terms of Section 1C. Presiding officer, despite what the First Minister told Oliver Mundell last week, this is a quasi-judicial process, and the only body that can expand its remit is the government itself, so I ask them to do that today. Liberal Democrats will support the motion before us today. As a member of the inquiry, I have been frustrated by what I can only describe as the grey wall of silence that we have encountered from the civil service in respect of nearly every aspect of our inquiry. From this legal advice, many other answers will flow. The government has clung to the legal privilege so hard during our consideration and our deliberations that the inescapable conclusion of any dispassionate observer must be that there must be some reason they don't want us to see it. The judicial review was launched to settle the legality of the handling process, but it was not the only means of doing so. Arbitration was offered by Mr Salmond on several occasions, not to adjudicate the complaints, but how the government had handled them. Now, there was obviously a clear advantage to the former First Minister in the privacy of arbitration, but so too was there an advantage for the complainers as well. That, for me, is what this is all about, and I credit Jackie Bailey for an excellent speech about why we should always remember the complainers at the heart of this investigation. Because judicial review is a winner-take-all event. We know from this one that one of the consequences was that the original complaints will probably never see the light of day again or ever receive fair hearing under any process used by the Scottish Government. But with arbitration, the complainers had a fighting chance at starting again, at having their complaints heard properly from the beginning and without public intrigue that the review brought with it. Without the legal advice, we will never understand why the government took that decision. The First Minister's own evidence suggests that the government were aware of the risk of judicial review from spring in 2018. Mr Salmond, as we've heard from Murdo Fraser, had advice from senior counsel suggesting that his case was very strong. It was a slam dunk. It is hard to imagine, therefore, that the government then didn't, at that point, also seek legal advice from the outset. Now, our committee is charged with understanding with whom the responsibility for this failure ultimately rests. And if at some point the government were offered the opinion of senior counsel that the probability of victory was vanishingly small, then why on earth did they proceed with it? Presiding officer, it would have been much easier just to set fire to £500,000 on the front step of St Andrew's House and leave the women at the heart of this utterly exposed. This Parliament needs answers, and those answers lie in part in the publication of the government's legal advice. Thank you.
Thank you very much. I would just urge members that we don't have a lot of time for this debate, so please keep your remarks to the 4 minutes you're allocated. I call Margaret Mitchell to be followed by Bruce Crawford. Margaret Mitchell.
Thank you, Presiding Officer. On the 8th of January 2019, Lord Pentland announced that the Scottish Government had conceded the former First Minister Alex Salmond's petition for judicial review on the following grounds: that the procedure was unlawful, the decision taken in procedurally unfair circumstances, and was tainted by apparent bias. The former First Minister was awarded an interim payment of £350,000, then a balance of £166,250 to cover his legal expenses, which were paid on the solicitor-client scale, reflecting the Scottish Government had conducted the litigation incompetently or unreasonably. On the 15th of January 2019, Parliament agreed to establish a committee of inquiry to look into the Scottish Government handling of complaints against the former First Minister. The then Alex Salmond harassment charges case followed, and that was sub judice. Nonetheless, the committee met in private throughout 2019 and up till June 2020, determined to do all the groundwork possible to enable it to hit the ground running when, on the conclusion of the trial, it was able to meet in public and begin the formal evidence. This it did for the first time in August 2020. However, when seeking the relevant information, To allow it to carry out its remit, the committee and its members have experienced huge frustration as deadlines for productions are missed or information such as that released in the Scottish Government's first tranche is supplied in a format which makes it virtually unintelligible. Quite simply, behind the scenes, it has felt like wading through treacle to get straight answers to questions or to receive information to allow proper scrutiny during evidence sessions. Instead, if produced at all, relevant deadlines are ignored and the necessary information is frequently received the night before taking evidence. Given this, is it perhaps not surprising we're having to resort to a parliamentary debate to call on the Scottish Government to waive legal privilege and release the evidence it received, despite there being precedents for this being done? Furthermore, the evidence in the public domain confirms that arbitration was offered and rejected by the Scottish Government well before the petition for judicial review was formally lodged in August 2018. Significantly, the unsuccessful trial to the judicial review then cost the taxpayer a minimum of a staggering £630,000. Information received regarding the suggestion for arbitration confirms the Scottish Government rejected arbitration because it was confident of the legality of the process. The former First Minister's senior counsel believed the process was unlawful. The legality would therefore have to be resolved either in private in a confidential and binding arbitration or in public in the Court of Session. If the former First Minister's legal advice was wrong, the current process for judicial review would proceed. If the Scottish Government's legal advice was wrong, it would discover that without the expense of losing in a public court. Crucially, arbitration guarantees confidentiality for the complainers, but they were never offered that choice. Presiding Officer, in order for the Inquiry Committee to effectively carry out its remit, the Scottish Government must waive legal privilege and release the judicial review advice it received. Only then can the required transparency and accountability be achieved for the complainers and the taxpaying public who paid the six-figure costs of the judicial review. I wholeheartedly support the motion Murdo Fraser's name.
Thank you. And I call Bruce Crawford to be followed by Daniel Johnson. Bruce Crawford.
Thank you, Presiding Officer. The motion being debated asks Parliament to call on the Scottish Government to publish all the legal advice it's received regarding a judicial review. Presiding Officer, in my contribution, I will inevitably cover some of the same ground as the Cabinet Secretary because his argument exposes the deep flaws at the heart of the Conservative position. The Conservatives laid this motion despite the fact that they're more than aware that in the UK it is the law officers who are responsible for providing legal advice to the government, and moreover, that successive governments of all political persuasions have observed a long-standing convention that the advice they receive from the officers is not disclosed outside government. Indeed, Murdo Fraser made that point himself in his opening speech. The convention being one which their own Conservative government at Westminster strictly adhered to. The clear rationale for this convention being well understood as enabling government to have access to full and frank legal advice. Indeed, this position is well laid out in the Scottish Government's Ministerial Code, where it states, ministers may acknowledge publicly they have received legal advice on a particular topic, but must not divulge either who provided the advice or its contents, whether it's from the law officers or from anyone else. This applies to all forms of legal advice. The Code goes on to say that this approach is required in order to take account of the public interest in maintaining the right to confidentiality of communications between legal advisors and their clients. Now, of course, it is true that exceptions have been made in regard to publicising truly exceptional circumstances, such as going to war in Iraq or in major public policy areas, as is being pointed out by the Deputy First Minister. I would submit to you, Presiding Officer, that the case being put forward by the Conservatives does not meet the bar of exceptional circumstance or major public policy. And they, I think, indeed the whole Chamber, knows this to be the truth. Therefore, in submitting this motion for debate today, they also knew full well that the Scottish Government position would be because it is well established. In such circumstances, the question's got to be asked: what was the purpose and motive behind the Conservative motion? Given the background, the only possible conclusion that can be reached is its purpose is an ill-conceived attempt to decondition the outcome of the committee inquiry into the Scottish Government's handling of the harassment complaints. Their motive, an attempt to politicise the process and undermine the credibility and position of the Scottish Government, no matter how futile that might be. Officer, to exacerbate matters, this motion is being brought forward during a coronavirus emergency that's now killed over 47,000 people in the UK, and very sadly claimed the lives of almost 400 people yesterday, and in the last 24 hours, 50 in Scotland alone. However, there is an important Conservative motion for debate today in the name of Donald Cameron in relation to COVID-19 deaths in care homes. I say to the Conservatives, in all seriousness, had they devoted all of their time to a motion concerned with the COVID-19 emergency, people in Scotland might actually have taken their concerns more seriously. But now, however, the truth has been bared for all to see. They would rather indulge in political stunts than properly address the very real and deep concerns of the people of Scotland regarding the COVID-19 emergency. Presiding Officer.
Thank you very much, Mr Crawford. I call Daniel Johnson to be followed by Annabel Ewing.
Thank you, Presiding Officer. This is an important debate because undoubtedly the circumstances surrounding it are some of the most troubling issues that we have dealt with since the creation of this Parliament and since devolution. As Jackie Bailey and indeed Alex Cole-Hamilton set out, the complaints at the centre of this are of the most serious nature. As Murdo Fraser has pointed out, there are serious questions that have been made publicly about the way in which the government arrived at its decisions and whether it was pursuing a particular agenda. And as Andy Whiteman pointed out, there are key questions about how the government used the advice that was available to it. And of course, there's the question of the over £500,000 that these circumstances and these decisions have cost the public purse. And it is with regret that I take exception to the comments just made by Bruce Crawford. But he made the point, asking whether the test of exceptional circumstances had been met. And I would simply put it to him like this. If a circumstance is where a former First Minister makes the accusations that have been made of the existing First Minister do not constitute exceptional circumstances, I simply do not know what would. And this is a matter of collective concern, because this and the circumstances surrounding these decisions are a reflection not just on the government, but on the Parliament and politics in Scotland as a whole. Because ultimately, power is not vested in the government, it is vested in Parliament. And we exercise that power on behalf of the Scottish people. And it's only through that sequence that the Scottish Government exercise its power on our behalf and ultimately in the public interest. And that is critical because that is what is at question. And I think Andy Whiteman set this out very well. But we need to understand the appropriateness of the actions of the Scottish Government. And the only way we can do that is by seeing the legal advice. Because there are critical questions. Why did they continue to defend the judicial review? Did political judgment override legal assessment? And if that did occur, then they failed, the Scottish Government failed to act in the public interest. And the only way we can make that determination, the only way we can judge whether or not that political judgment overrided the advice that they received was by seeing that legal advice, which is why it's so important that we see it. But there is the critical question of legal privilege. And I understand the arguments made by the Deputy First Minister. Legal privilege is hugely important if you believe in the rule of law and in individual rights. It's important that individuals are able to act in an informed way so that they understand their options and that they can investigate those without prejudice. And indeed, organisations have that same private interest and enjoy that legal privilege. And in that regard, the Scottish Government does indeed have legal privilege. But is it all exclusively a private interest it has? The Scottish Government is different to an organisation or an individual because it is acting on our behalf and on our interests. And it is absolutely right that it must be able to deliberate and decide and to make judgment. But that assumes that it acts in good faith and acts on its best judgment. And I think that is what has been called into question, whether that judgment was exercised or other elements were taken into consideration. But on top of that, there are other issues, such as this is retrospective rather than prospective. And again, that is very much akin to what happened in terms of the release of legal advice in the Trams inquiry and the Blood inquiry. But overall, public interest has been challenged itself. And this is the key point. Has the machinery of government been used for political agendas and personal interests rather than that of the public? And the only way we can answer that is by seeing the legal advice. And I would urge the government not to wait till the vote this evening, but to release and publish the legal advice, because I think they are morally required to do it, and they shouldn't require a vote of Parliament to force them to do so. Thank you.
Annabel Ewing to be followed by Annie Wells.
Thank you, Presiding Officer. And my contribution today in this short 1 hour, 10-minute debate that the Tories opted for in terms of the whole of their opposition time, they only chose half of it, I would wish to focus on the issue of legal professional privilege. And perhaps it would be prudent in the best interests of prudence to refer members to my entry in the Register of Interest, wherein they will note that I am a member of the Law Society of Scotland. I hold a current practising certificate, albeit that I am not currently practising. Given the subject of the motion concerns at its heart legal professional privilege, that is what indeed I will focus on. And this concept, of course, is centuries old. And at its heart, it is deemed essential to the operation of the legal system and the administration of justice. As far as governments are concerned, this principle underpins the convention that legal advice is not published so as to ensure that decisions can be informed by comprehensive and open legal advice which can be provided without fear or favour. The obverse of this would involve a risk that legal advice could be skewed if publication were to be the norm. The convention of not there for publishing legal advice has been followed by governments across these islands and indeed in many other countries. There have, of course, been a few exceptions to this, and we've heard about that in Scotland in terms of judge-led inquiries in the main. Also, of course, there have been two notable exceptions in recent times in terms of the UK government's approach. The first case concerned the publishing by the Tony Blair Labour government in 2005 of their Iraq war advice, and the second exception concerned the publishing by the Theresa May Tory government in 2018 of their Brexit advice. These exceptions involved what must be regarded as seismic foreign policy decisions, that is to say, Labour's Iraq war decision representing a monumental foreign policy disaster, and the Tories' Brexit shambles representing an acute case of economic self-harm. Given the seismic nature of these issues, I would contend that publication of advice in these particular circumstances sets no precedent, as the exceptional approach taken should be understood very much in context. And incidentally, it is perhaps worth pointing out that notwithstanding, I've only got 4 minutes, that notwithstanding the truly exceptional circumstances justifying the publication of the Brexit advice, these exceptional circumstances were nonetheless not sufficient to garner the support of the Scottish Tory MPs, with David Mundell MP, Douglas Ross MP and the other Tory MPs resisting publication. And I don't recall at that time any Tory MSP in this chamber raising an eyebrow about that or calling for publication of the Brexit legal advice. As far as the Ministerial Code and the public interest test is concerned here in Scotland, and taking into account the operation of the Convention, it is, I would submit, by no means clear that a compelling case has been made thus far in this debate today to waive professional legal privilege. Concurrently, of course, as we have heard, there is an ongoing parliamentary committee inquiry in this Parliament, and I understand that the Lord Advocate has given oral evidence to that committee and could indeed be recalled before the committee if that was felt necessary and appropriate. In conclusion, Presiding Officer, I would say that in 21st century Scotland, there may indeed be merit in proceeding with a jurisprudential debate on the reach of the legal professional privilege principle, in particular as far as the role it plays in terms of government legal advice is concerned. But surely it would be important that such a debate should be conducted in a measured, objective and coherent fashion, and not simply fitted round any particular individual case, and that in a 70-minute parliamentary debate. Indeed, perhaps, in fact, the better forum could be, for example, the Scottish Law Commission, which brings great weight to the legal issues that it deliberates upon. So for the foregoing reasons, Presiding Officer, I will not be supporting the motion today. Thank you.
Thank you very much. And I call Annie Wells to be followed by Shona Robson. Annie Wells.
Thank you, Presiding Officer. I very much welcome the opportunity to speak in this important debate. And it is right that the responding to COVID-19 pandemic has been at the forefront of our minds and dominated this Chamber's proceedings, as we are in the midst of a destructive second wave and head into the winter months. This will become even more crucial as we look to protect our NHS and save lives. Having said that, Presiding Officer, I'm afraid that this debate can wait no longer. It is right the Scottish Conservatives and Unionists are leading on this today. The extraordinary affair has not only made a mockery of this Parliament and shamed the SNP, but it has also been a slap in the face to the people of Scotland. Along with the discredited hate crime bill, the conduct of the Scottish Government throughout this affair is rapidly forming part of a larger pattern where it thinks it can simply cast aside the concerns of the Chamber and do what it likes. We will not simply stand by and let this happen. With the legal battle having cost the taxpayer over half a £500,000, an eye-watering amount and a complete waste of public funds, considering the severe economic harm of the coronavirus pandemic, the people of Scotland deserve answers as to why this eye-watering amount of money was spent in the first place. As such, my party, and indeed as members across the Chamber, are determined to get to the bottom of this particular fiasco and force the SNP to come clean. With its contemptuous attitude towards the Special Committee, the SNP continues to withhold essential information in the form of legal advice related to the Alex Salmond inquiry from this Parliament, and it is vital that this is released immediately. They claim they can't publish legal advice, but this is hypocritical to say the least. From airstrikes in Syria to the EU withdrawal agreement, the SNP have urged the UK Government to publish legal advice on a whole range of issues in the past. Ascertaining to what the legal advice was in regard to Mr Salmond's judicial review is crucial evidence. So what is it the SNP have to fear? This is information that could allow us, as parliamentarians, to properly scrutinise and establish what exactly went wrong in this whole doomed affair. Like many others, I am sick and tired of this government treating the Parliament and the Scottish people with utter contempt. The SNP's attitude is quite simply staggering and stinks of sheer arrogance. In many people's eyes, they have lost all credibility as a result of this affair. That's why I have repeatedly urged this Chamber and MSPs of all political persuasions to stand up and speak with one voice, to call on the SNP to immediately release the key documents. So far, the extent of the cross-party group generated from members across the Chamber has been extremely welcome and very refreshing to see. This kind of unity from members further signals that the government is clearly in the wrong. Our ability to act with purpose and collectively endeavour to get answers for Scotland will be crucial in the next few months as the committee continues its inquiry. Presiding Officer, simply put, In the face of SNP contempt, the reputation of this Parliament is on the line. It's high time we stand up and be counted. Thank you.
Thank you very much, Ms Wells. And I call Shona Robertson before we move to closing speeches. Shona Robertson.
Thank you, Presiding Officer. I feel that today has, for me, been a bit of a tale of two parliaments. The first this morning was a meeting of the COVID-19 committee in which I served, scrutinising in detail the First Minister on the new tier system and indeed her handling of the pandemic more generally. Serious matters indeed. And however, I can't help but contrast that with this afternoon's Conservative business. This debate, about which I feel more sorrow than anger, could not be more different from this morning. And this does feel to me like political game playing at its worst. Bruce Crawford, in his contribution, exposed the purpose and motive behind this motion today, and I think it stands for itself. Don't get me wrong, the Committee on the Scottish Government's handling of harassment complaints is looking at some very serious matters, and that absolutely require full investigation. But therein lies the point. We're in the middle of the committee inquiry, so how can it be right for the Tories to bring forward such an ill-timed motion which cuts right across the work of that committee? The committee tasked with investigating this matter should be given the time and space to scrutinise what went wrong and why. Furthermore, the Tory motion focuses specifically on the issue of the legal advice, which is interesting, and I want to make three key points about this. Firstly, the protection of legal professional privilege has been relied upon by every Scottish and UK government of all political colours and must be respected. Secondly, the continued existence of legal professional privilege for the Scottish Government helps to ensure the rule of law and the administration of justice. And thirdly, the Scottish Ministerial Code recognises the existence of legal privilege and indeed is clear that ministers can say that legal advice has been obtained but must not divulge this. The exceptions made previously have been made on issues of public policy, which is not the case here. The Code also notes the public interest in ensuring that the Scottish Government can have confidential communication with their lawyers. The Lord Advocate's submission to the committee expanded on this further by explaining that good government is ensured by enabling ministers and officials to seek legal advice whenever they need to. It's also worth noting that the Scottish law officers must be consulted and must consent before any legal professional privilege could be waived. And the Code confirms that law officers would have to be convinced that there are compelling reasons in support of waiver. Yet some members supporting this motion appear to be saying that the Scottish Government should release this legal advice, even if it was to be the case that the law officers had said that that should not happen, and it would be against the agreement of law officers, and therefore, I believe, would be a breach of the Ministerial Code. It's also worth noting that the Lord Advocate has made himself available to provide oral advice on these relevant matters. To conclude, Presiding Officer, the correct parliamentary process is the committee investigation, and it should be allowed to run its course, free from the distractions of parliamentary debates such as this. And therefore, I urge members to vote against this motion and to support the amendment in the name of John Swinney. Thank you.
Thank you very much, Mr Robertson. We move to closing speeches. I call Jackie Bailey to be followed by John Swinney. Jackie Bailey.
Thank you very much, Presiding Officer. A short debate, but I think an illuminating one. The opposition parties across the chamber are of one mind. They believe the Scottish Government should provide the committee with its legal advice in relation to the judicial review of the harassment policy. SNP members on the committee agree to. The remit for the committee was agreed by the Parliament as a whole. This is about the credibility of this Parliament and the accountability of the Scottish Government. The committee has a job to do, and to be blunt, the Scottish Government is obstructing its work. Whether it's withholding information or the sometimes apparently serial memory loss on the part of senior civil servants, it amounts to the same thing: a lack of cooperation with the committee, and some, not myself, might say a deliberate lack of cooperation. The First Minister's commitment was made on behalf of the Scottish Government which she leads. I appreciate that she has recused herself, as she will be a witness to the committee. But that is not an excuse for the Scottish Government not to fulfil that promise. The Deputy First Minister can release the legal advice if he chooses to do so. Andy Whiteman, in an excellent speech, explained exactly why that was the case. But this is not that the Scottish Government can't tell us. This is that the Scottish Government won't tell us. And let me give you one example of the obstruction we've faced. Early letters from the Scottish Government, from the Deputy First Minister, about the judicial review said they could not share any information, as this was a matter for the Court of Session. Now, that simply wasn't true. They could share the information they, as the Scottish Government, had presented to the court with the committee. But it took the attendance of the Lord Advocate giving evidence under oath and a letter from the committee to the Court of Session to establish that that was the case. We have heard that an army of lawyers were involved for the Scottish Government, at least 10 to 12 of them. So I'm not persuaded that the Deputy First Minister did not understand that he couldn't share this information. So if it wasn't ignorance that stopped information being shared, what on earth was it? Why did it take the presence of the Lord Advocate at committee under oath to stop the nonsense coming from the Scottish Government? Now, I'm not going to rehearse the evidence that the committee has received. Suffice to say, I do have genuine concerns about the blurring between the party and state. But that is for another day. The committee has been told that the legal advice was taken throughout the judicial review process. The FOI from September 2019 tells us about the 17 meetings with Council, starting on the 23rd of August up to the 7th of January. The Council remained the same throughout, so there would be consistency in their thinking and their advice. Just yesterday, the Scottish Government's lawyer in charge agreed that even when the prospects of success were not good, the government might still decide to proceed. Now, that might be questionable, but we need to have the legal advice to understand this. But when the prospects nosedived after the role of the investigating officer was revealed, why did it take the Scottish Government almost 3 months to concede the case? Having the legal advice provided will help to address these fundamental points in relation to the judicial review. But of course, Presiding Officer, the Scottish Government has form. We are used to not getting information from FOIs. We're used to that being withheld. Now they're withholding information from the committee. They even tried to withhold information from the Court of Session until they were forced to produce it. It is very much secret Scotland with this government. So it's time for the Scottish Government to end the secrecy, give the committee the legal advice, or tell the people of Scotland what it is that you have to hide.
Deputy First Minister John Swinney.
Presiding Officer, Jackie Baillie made the comment in her closing remarks that she was not going to rehearse the business of the committee and the substance of the inquiry, and some members have raised elements of the substance of the inquiry, and I just want to make it clear to Parliament at the outset of my closing remarks that I will not reflect on any of the issues of substance about the inquiry. I think that would be inappropriate for me to do so, since there is a committee process underway and it is properly the business of the committee. I want to also address the issue, Jackie Baillie has touched on it, Margaret Mitchell has touched on it as well, about the nature of the documentation that the government is providing to the committee, because I don't think either of the characterisation by Jackie Baillie or by Margaret Mitchell was in any way fair or appropriate or representative of the issues about which the government has got to be mindful in the way in which we present information to the committee. The committee itself has established, understandably and quite appropriately, stringent rules about how information must be presented to ensure it complies with the various legal obligations and requirements that are on the committee and that are also on the government, which have been applied in many circumstances by decisions of a number of courts. And for that reason, I think it is unfair to criticise documents that are redacted by the government when the government is simply acting in a fashion to ensure that we do not breach the law in relation to the content of that material. And I think Parliament should accept the fact that the government is going to significant lengths to ensure that we comply with a whole series of legal requirements under which we are operating. That is, of course.
I thank John Stoney for giving way, but does he not recognise the argument he's just making makes it even more compelling that this judicial review legal advice, which can be published, is published so that the maximum information is in the public domain?
That's true the point that I'm coming on to, which is about the material that the committee already has. Now, the committee already has from the government the pleadings that have been the substance of the legal argument that the government has put to the courts in relation to the judicial review. Those pleadings have been, the various changes to those pleadings have been set out to the committee openly and transparently in compliance with all other obligations under the government that are placed on the government. And in addition to that, the government has provided the committee with a substantial explanation of various events in the process of the judicial review to ensure that the committee is able to understand what was influencing the decisions that the government was making as the judicial review took its course. Of course.
Hamilton.
I'm very grateful for the Cabinet Secretary giving way. Can we try this another way then? I understand that you're not going to release the legal advice, but given the decisions that you referenced that the government was taking, did either the Lord Advocate or senior counsel at any point threaten to resign because of the decisions this government was taking in respect of that legal advice?
Cabinet Secretary.
Well, what I'm setting out to Alec Cole-Hamilton, and what I said at the outset, was that I'm not going to get into the substance of any aspect of these processes because it's not appropriate for me to do so. What I'm saying to Alec Cole, to Parliament, is that the government has shared the explanation of the case that we have set out to the court and the explanation that goes with it in the form of the timeline. Daniel Johnson, in his contribution, made, if Mr Whiteman will forgive me, I want to address a point that Mr Johnson raised. Daniel Johnson essentially made my argument for me in the contribution that he made, because Mr Johnson accepted that legal professional privilege is vital in the rule of law. Mr Johnson also accepted a central point that I've put in the argument today, that government in all circumstances must be free, particularly in a case of litigation, to explore all options without prejudice in relation to the handling of any particular case. And Mr Johnson went on to say that the government carried additional responsibilities because we had to act in the public interest. And that is absolutely correct, because there are a multiplicity of different circumstances. If Mr Johnson, I'll let him in a second. It's a multiplicity of circumstances where the government is acting in the public interest in a situation, an environment of litigation, where those who advise us must be in a position to give us full and frank advice without fear of it being published, because from the government's point of view and the public interest point of view, that advice may end up becoming more cautious than it needs to become. I'll give way to Mr Johnson.
Before the Cabinet Secretary gives way, I'm afraid the Cabinet Secretary only has 5 minutes. I'm conscious that he only has 5 minutes. He's given 2 interventions. I'll give the Cabinet Secretary another minute back to draw his marks to a conclusion, but I wouldn't suggest taking another intervention.
I thank the Cabinet Secretary for giving me, but would you not acknowledge I also said that when that public interest had been called into question, whether or not the government is acting into it, that needs to be answered, and the only way to do that would be to see the legal advice. Would you not understand that point?
No, and forgive me, President Officer, I thought I had 6 minutes, so my apologies for extending my contribution. I think the answer to Mr Johnson's question is in what I've just said to Parliament about the combination of the explanation, the publication of the pleadings, and also of the detailed timeline, which provides an account of the decision-making that the government made in these circumstances. For those reasons, Presiding Officer, I invite Parliament to support the amendment in my name and to reject the Conservative motion.
Thank you very much, Deputy First Minister. And can I call on Oliver Mundale to draw our debate to a conclusion?
Thank you, Presiding Officer. It gives me no pleasure to close this afternoon's debate, because credit where credit's due, SNP backbenchers were right on one thing. This debate shouldn't have been taking place. It shouldn't have needed to take place, because if the Scottish Government had kept its word opposition parties wouldn't be forced to come to this chamber and waste precious debating time getting something that had been promised in the first place. And it's only a government that had dug itself so deep into a hole that would adopt a strategy of denying reality. For the truth is this: no matter how many times the once honest John Swinney hides behind the paper-thin excuse of government conventions on the publication of legal advice, this is not a conventional situation.
Point of order, Annabel Ewing.
The member has just referred to the Deputy First Minister as the not honest John Swinney. I mean, I'm sorry, surely to goodness that must not be an acceptable thing to say in this debate.
I'm sorry, he said I once honest, and I was very conscious of the remark. However, I'm sure Mr Mundell also was conscious of the reaction it got and will be careful about his choice of words. Mr Mundell.
Thank you, Presiding Officer. For the SNP who call for legal advice to be published every time there's a decision that they don't like, to try and hide behind this particular defence, is just the latest in a long line of comments and actions that are just not credible. It doesn't wash with the public, and it demeans Scotland's national parliament. Given the allegations that have been made and the concerns that continue to surround this matter, the idea that the Scottish Government and the First Minister have the right to decide what is or isn't in the public interest is quite frankly laughable. As Andy Whiteman has rightly pointed out, self-interest is the issue here. And I wonder myself, did the Cabinet Secretary see the legal advice before this decision was taken? And if he did, how can he objectively come to Parliament and say that there's no public interest in publishing it? On top of that, the number of admissions and mistakes lacks credibility, and Parliament, in my view, has been misled. Presiding Officer, I will not... Yes, certainly.
First Minister.
I wonder if Mr Mundell would reflect on the comment that he's just made about the way in which information has been supplied to the committee. Does he not acknowledge the point I made, that there are significant legal constraints that the government must follow in the supplying of information to the committee, or it would be in contempt of court?
Oliver Mundell.
I don't deny reality, unlike the government, but I do think the government's attitude has been wrong throughout. And, Presiding Officer, I won't repeat the language I've used in the past to describe the First Minister's words and actions, because I want to be able to join colleagues in voting tonight to demonstrate clearly that the government is out of step with Parliament. But dodging key questions just adds to the stench that hangs over this whole sorry affair. It's convenient and easy to argue that this inquiry and issue is somehow rendered unimportant in the context of current events. I appreciate that some people may sincerely believe this to be the case, but we cannot allow such allegations surrounding a serious abuse of state power and questions over the integrity of government processes and procedures to be left unanswered and unchallenged. Indeed, for me, this is more about politics. Is about more than just politics. It's actually quite hard to speak, Presiding Officer, when you're being heckled. Indeed, this is about more than just politics or individuals. And I have a great deal of respect for those such as Alex Neil, who have been willing to speak out. And I strongly suspect that many members across the political divide know in their heart that something has gone very badly wrong in this case. And at the very least, we're not being told the full story. I suspect many members like me would now agree with Alex Neil that a judge-led inquiry might have been more successful in extracting the required information than MSPs. I say this as it's now clear that the First Minister and her government's commitments to transparency and full disclosure are worse than meaningless, and that these promises were only uttered to buy more time. After all, if you were serious, Presiding Officer, about transparency, if you were serious about helping Parliament get to the bottom of this, if you were serious about restoring faith in the Scottish Government, if you were serious about respecting the high office that you hold, you would maybe, just maybe, be a little bit more proactive when it came to disclosing the full facts and key documents. I suspect even John Swinney knows the reason why the Scottish Government haven't adopted this approach, and that is because they've got something to hide. Presiding Officer, if this assertion is wrong, then it's easy for the Scottish Government to disprove it. After all, sunlight is the best disinfectant. Let's get the full facts into the public domain and let members of this Parliament and the people of Scotland judge the actions and decisions taken for themselves. I suspect the full disclosure of information might even assist the First Minister with her memory. It would certainly let us move on more quickly and allow the valuable resources of this Parliament, which have been highlighted by so many SNP members this afternoon, to be refocused. In conclusion, Presiding Officer, I've lost count of how many times in my short 4.5 years in this Parliament that Nicola Sturgeon has said that leadership is about doing the right thing when it's difficult for you. I struggle to look at this decision and I find it almost impossible to think that hiding behind legal conventions shows any kind of leadership. If the SNP government and the First Minister want to make a start at restoring trust in this inquiry process, then they must listen to the will of Parliament if it votes at decision time to demand the publication of this legal advice. To do otherwise will confirm many people's worst fears about their motives. Thank you, Presiding Officer.
Thank you very much. And that concludes our debate on the Scottish Government's handling of harassment complaints. And we're going to move on shortly to the next item of business. There will just be a short pause while we move on. I urge any members that need to leave the chamber to be careful in observing social distancing.